This will be the third lecture on cybercrime in regards to Indian scenario, in which we would like to discuss certain important leading cases. So the first important leading case is Punahou Ancillaries Private Limited versus Punjab National Bank. It is a case of 2018, and this very leading case relates to Section 66 of Information Technology Act, which applies to any conduct described in Section 43 of the Act, that is dishonest or fraudulent. There can be up to 3 years of imprisonment in such instances, or a fine up to Rs 5 lakh. And in the instance case in Pune Auto Ancillaries Private Limited, Pune versus Punjab National Bank, which headquarters is at New Delhi, and others in 2018. Regarding the very fact of the case, Rajesh Agarwal of Maharashtra's IT department representative in the present case ordered Punjab National Bank to pay Rs 45 lakh to Manmohan Singh Mathura, MD of Pune West Farm, Pune Auto Ancillaries. In this case, a fraudster transferred Rs 80.10 lakh from Mathura's account at Punjab National Bank at Pune after the latter answered a phishing email. Since the complainant responded to the phishing mail, the complainant was asked to share the liability. However, the bank was found negligent because there were no security checks conducted against fraudulent accounts open to defraud the complainant. And now we would like to discuss another important leading case, and that is falling under the provisions of Indian Penal Code, and in particularly section 354D, and the very leading case is relating to Charan Lenka versus State of Odisha, which was decided in 2017. So, as per the provisions of section 354D of the Indian Penal Code, which provides that stalking, including physical and cyber stalking, is described and punished in this chapter. The tracking of a woman through electronic means, the internet or email, or the attempt to contact her despite her disinterest, amounts to cyber stalking. This offense is punished by imprisonment up to 3 years for the first offense and up to 5 years for the second offense, along with a fine in both the cases. So, in the important leading case, that is Charan Lenka versus State of Odisha, a victim in this case, Charan Lenka, has received a series of options messages from an unknown number that has damaged her reputation. The accused also sent emails to the victim and created a fake account on Facebook containing morphed images of her. The High Court therefore found the accused prima facie guilty of cyber stalking on various charges under the Information Technology Act 2000 and Section 354D of the Indian Penal Code. And the subsequent next important leading case is relating to Anil Kumar Shrivastava versus Additional Director, Maharashtra Family Welfare Department, and that is of 2005, where exactly in that particular leading case relating to the provisions and that is under section 465 of the Indian Penal Code, which provides that the punishment for forgery. So, under this section, offences such as the spoofing of email and the preparation of false documents in cyberspace are dealt with and punished with imprisonment ranging up to 2 years or both. So, in the instance case, Anil Kumar Shrivastava versus additional director in 2005, the petitioner had forged the signed signature of the additional director and had then filed a case that made false allegations against the same individual due to the fact that the petitioner also attempted to pass it off as a genuine document. The court held that the petitioner was liable under section 465 and section 471 of the Indian Penal Code. And another important leading case that is relating to cyber crime in Indian scenario is Gagan Harsh Sharma versus State of Maharashtra, decided in 2018. So, the Bombay High Court in this particular leading case addressed the issue of non-bailable and non-compoundable offences as under section 408 and 420 of the Indian Penal Code in conflict with those under section 43, section 65 and section 66 of the IT Act, that is bailable and compoundable. So we have to discuss such offences may end up being bailable under the IPC but not under the Information Technology Act, and vice versa, or may be compoundable under the Indian Penal Code but not under the Information Technology Act, and vice versa, due to the overlap between the provisions of the IPC and the Information Technology Act. For example, if the conduct involves hacking or data theft, offences under section 43 and 66 of the Information Technology Act are bailable and compoundable, whereas offences under section 378 of Indian Penal Code are not bailable, and offences under section 425 of the Indian Penal Code are not compoundable. Additionally, if the offence was the receipt of stolen property, the offence under section 66B of the Information Technology Act was bailable, while the offence under section 411 of the Indian Penal Code was not. In the same manner, in respect of the offence of identity theft and cheating by personation, the offences are compoundable and bailable under section 66C and section 66D of the Information Technology Act, whereas the offences under section 463, 465 and 468 of the Indian Penal Code are not compoundable, and the offences under section 468 and 420 of the Indian Penal Code are also not bailable. So these are the important leading cases decided by the high courts of Bombay or Odisha or the High Court of Maharashtra. So, in these particular leading cases, side by side, we have discussed the relevant provisions of the Information Technology Act of 2000 and also the relevant provisions of the Indian Penal Code of 1860.